Hey everybody, welcome to the HR Leadership and Spotlight Show. My guest today is an employment attorney. I like talking about and talking to HR professionals and leaders out there, but today we've got an attorney, an employment attorney. There he is right there. How you doing, Keith? So my guest today, he has been practicing since 1999. He worked for one of the largest firms in the country and then became an entrepreneur, broke away, started his own law firm. Now, I met Keith because he is extremely active. Keith is out there. He speaks at our Central Florida Hotel Lodging Association meetings. He's spoken at our SHRM meetings. Keith is a really active attorney. He's out there partnering with folks, and I'll tell you what, really there's so much more he can talk about. He represents primarily management and employers, and Keith, I'm going to let you talk a little bit about that, but without further ado, folks, my friend and colleague Keith Hammond. Keith, how you doing today?
I'm doing well, Chuck. How are you doing?
We're fantastic. Keith, I know we got a lot to talk about today, but our logo with the coffee mug and the microphone for the HR Leadership Spotlight Show, but why don't you talk to us about what you brought today?
Sure. And first, Chuck, thank you for having me on. It's a pleasure to be here. Great to see you, and hopefully some familiar faces will be viewing this podcast.
Absolutely.
So, my mug today, it's not going to show up very well, but here it is, and what you can probably barely see is the seal of the United States District Court for the Middle District of Florida. So I've had this mug for 20 plus years, and I have it because my first job out of law school back in the very late 90s was working for a federal judge over in Tampa, where I was a law clerk. And what a law clerk does is basically assist the judge in performing legal research, maybe drafting proposed orders and opinions for the judge to consider, or assisting with a portion of an order or an opinion, and essentially really working in chambers to make sure that the court system operates the way it's supposed to. I held that position for 2 years until 2001. And the reason that I use this as my mug is to remind me of not only that experience, but also that my primary goal these days is to keep my clients out of court.
Of course.
Yes, awesome. Primarily what I do, of course, is provide advice and counsel to HR professionals, managers, even owners of companies, with respect to really any aspect of workplace law, whether it be discrimination, harassment, retaliation, or FMLA issues, leaves of absence, wage and hour, complying with wage and hour regulations, enforcing restrictive covenant agreements like non-compete agreements, and even workplace safety, OSHA. OSHA these days is actually quite a big thing, whereas a few months ago even, it wasn't, but now it is. And I would say that, typically that's what a management side employment lawyer does, provide advice on a day-to-day basis for those things, as well as you mentioned, being out there in the community, particularly the HR community, speaking at seminars, putting on your own seminars in some instances, and others it would be speaking at Central Florida Hotel and Lodging Association seminars, or HHRA, Hospitality Human Resources Association, or SHRM, or there's another association for corporate counsel called ACH, the Association of Corporate Counsel. So that's frequently what I do. And of course, with that territory comes litigating. If an employer gets sued for violating one of those workplace laws, I represent the employer in litigation. And we end up here back in this court, the United States District Court, more often than not. So that's kind of my story.
Yeah, no, so just to point out, now, Keith, you were based in Orlando, Florida, but you can represent clients throughout the country. Would that be true, or how does that work? Middle
Sure.
District, circuit courts, how does that all work with you?
Yes, you need to become admitted to any court in which you practice. I'm
Hmm.
admitted to every court in the state of Florida, both federal courts and state courts. I've also litigated across the country on behalf of clients that for whatever reason wanted me involved in the case, even though the case was pending in, let's say, New Mexico or Chicago or somewhere else. And there is a procedure to become admitted on a special individual case basis in those jurisdictions. And I think at last count, I've probably appeared in about 11 other jurisdictions besides Florida.
Okay. And, now we're recording this in July of 2020, and you mentioned OSHA. OSHA's a big deal now. Just tell me what's going on.
Yeah, well, the COVID-19 pandemic is what's going on. And it's been
Right.
going on since the middle of March, probably before that in terms of the scientific aspect of it, but in terms of the workplace law aspect, beginning in about mid-March of this year, 2020, we started seeing more governments come out with stay-at-home orders. And as part of those stay-at-home orders, many businesses had to close their doors, but some did not. For example, if you've heard the terms critical infrastructure or critical employee, what that refers to is a designation of your industry as being critical to the country's infrastructure, thus allowing you to remain open during the pandemic. And there were and still are many employees who were concerned that, hey, if I have to go into work, I'm concerned about my safety. I'm concerned that I will contract COVID-19 and either I will suffer severe health implications or I might pass it along to a loved one who will. And OSHA ties into this because OSHA is the federal law that requires generally all employers to provide a safe workplace.
Right.
There are penalties for not providing a safe workplace. The law, OSHA itself, is so generalized that it does not discuss OSHA specifically. Now, granted, since then, OSHA has come out with a few guidelines as to what steps ought to be taken when you learn that somebody in the workplace has been diagnosed with COVID-19. So OSHA has become a considerably larger portion of my everyday practice than it has ever been, candidly.
Okay.
And it's not just OSHA, of course. When we are talking about COVID-19, there are all sorts of implications under the Americans with Disabilities Act. What if an individual has a disability and requests an accommodation? And the Equal Employment Opportunity Commission has provided guidance on that as well. If you go to the EEOC's website, which is simply eeoc.gov, there's actually a tab there for COVID-19 where they have frequently asked questions. They have guidance that they update periodically. In fact, I think it may have been updated only within the last couple of weeks. So that's certainly something that I do on a frequent basis, is check in on those websites to stay on top of what the updates are. And it will come as no surprise, of course, that things can change on a day-to-day basis. And Chuck, I know that you have been the recipient of some of my mass emailings to clients and others about what those changes have been. So staying on top of those changes has been a significant portion of my practice lately.
Right. And I got to tell you, I've been on your website, and we're going to talk about how people can get in touch with you a little later, but you've got a lot of great resources on there. You actually have a webinar you did a couple of weeks ago, so it's great stuff. Keith, I know you talked to other employment attorneys out there, both ones that represent I don't know what the term you would use, but that represent individual, let's say, employees that are upset with their employers and companies. And you talk to, obviously, attorneys that represent companies. And I remember maybe a week or two ago, you said one of the big things that you've seen or people have talked about, right, is that there's COVID-19 retaliation lawsuits. And I didn't know if you could expand on that. I thought that was fascinating.
Yeah, absolutely. You may recall that in April of this year, Congress passed the Families First Coronavirus Response Act, the FFCRA, which for employers was significant because it provided for a type of paid time off in certain circumstances. For example, if you were subject to a federal, state, or local quarantine order, including a stay-at-home order, you were entitled to up to 2 weeks of paid sick leave for that time off that the employer paid out and received a tax benefit on. So it was a dollar for dollar, basically tax rebate for every dollar the employer had to pay out to the employee in that circumstance. That law also contained an anti-retaliation provision. And I suppose I should mention that this law applied only to employers with 500 or fewer employees, not to some of the larger employers that are out there. But the anti-retaliation provision essentially said that employers are prohibited from retaliating against any employee who was entitled to the paid sick leave.
Right.
And what I'm hearing now, more and more, are instances where an employee returns from that paid sick leave and has some problem with the boss, whether it's related to that paid sick leave or not. The employee perceives that it is, and can bring a retaliation claim under the law. So for employers out there, this is what's on the cutting edge, and we expect to see more and more of it throughout the year as more and more employees are taking that paid sick leave.
So why? I guess that's the big question. Why are employees running into this? Why are employers doing that? I can't imagine employers are doing it on purpose because they want to be sued, right? I mean, maybe they are, maybe they're not. But why do you think that's happening? Is it they're not informed? They don't have good info. What's your take on that?
Well, in my experience, Chuck, this speaks not only to this particular form of retaliation, but many forms of retaliation or allegations of retaliation, is that when an employee is dissatisfied with his or her relationship with the boss or with the company, they go talk to an employment law attorney. And one of the questions the employment law attorney will ask is, oh, well, did you recently make a workers' comp claim? Did you recently complain about perceived discrimination or harassment? Now they're asking, did you recently take the paid sick leave? And if there's some connection between taking the paid sick leave or complaining of harassment or filing a workers' comp claim, there is a retaliation claim that the employee could bring. So I don't see the retaliation allegation in and of itself being anything new. What is new is the vehicle that they can bring that retaliation claim in now, the FFCRA. And frankly, my experience is not that the clients that I work with are out to retaliate against anybody. Rather, for whatever reason, there's a dispute in the workplace, and relatively close in time to that dispute, there was, the workers' comp filing or the paid sick leave or complaining of the harassment or the discrimination. I'm sure there are employers out there that want to get rid of employees who do that. And I think that's a very compelling narrative to the general public as well, or to a jury. But normally, many times when I'm contacted about an issue in the workplace where there is a concern that the employer's actions might be construed as retaliatory, there's another side to the story. The employer's side to the story has nothing to do with the protected activities such as the workers' comp claim, the harassment complaint, or taking the paid sick leave. So a lot of what I do is I'm on the phone with employers, walking them through the analysis, both legal analysis and the risk analysis. And many times there's not a black and white answer to the question of, hey, can I fire this person without being held liable for retaliation? The answer many times is I don't know. Right. There are arguments on both sides of the fence, and what level of risk are you willing to take?
Isn't that a typical attorney answer? Well, I don't really know, but like a lot of times we just want a yes or no, Keith. Can you give us a yes or a no? And
I would say that Chuck, the number of times I can give a yes or a no is far fewer than the number of times that I give the well, it depends answer. Right. But there's a reason for that. The reason for that is the law itself isn't black and white. Title VII was passed in 1964, and it took until 2020 for the U.S. Supreme Court to announce that the prohibition on discrimination based on sex extends to sexual orientation and gender identity. So for how many years was it? We didn't know the answer. If you
Right.
were in Chicago, by the way, in 2017, 2018, 2019, the answer there was yes, sexual orientation and gender identity are protected classes. But if you were here in Orlando during those years, the answer was no, it was not. So that goes to illustrate why so frequently we have to answer, well, it depends.
Right. And that's based on now in Orlando there were, unless there were local laws, right? But you're talking federally. There were circuits, right? So we're in the 11th circuit here in Florida, but the 5th circuit maybe up in Illinois, right? Wisconsin, Indiana, they ruled that sexual preference was a protected class, correct? That's
right. That's the 7th
you
circuit,
told
but
me
you're
that.
absolutely
Yeah.
right otherwise. That's correct. That's correct.
All right. So, there are, it seems like there's a lot to consider. Employment law is a dangerous sphere. So don't do this on your own, right? Is that what we're hearing?
There is definitely that component to the don't do this on your own. Another type of phone call I frequently get is from the HR director or the owner of the company who has made up his or her mind as to which way they want to proceed. And they're basically looking for validation. And sometimes I tell them, yes, it's perfectly legal to take whatever course of action, but sometimes I need to pump the brakes, and it might not be for obvious reasons. Something I frequently tell clients is that if employment law was based on common sense all the time, we wouldn't be in business. You or I wouldn't be in business.
I actually like that phrase there. I like that. That's a good one.
Let me give you an example of that. Most discrimination law is based on the concept that you should treat people in similar circumstances the same, right? Regardless of their religion, regardless of whether they have a disability, regardless of age, if you treat somebody differently because of one of those categories, you're breaking the law. So here's where things might, right. Where things might take a bit of a logical twist here is just to throw out a pretty standard example for you or me, Chuck, would be, well, I have a disabled person who wants to leave work a half hour early every Thursday so they can make it to a medical appointment. And the owner of the company, who's never had experience with HR law, might say, well, no, I can't allow that person to take a half hour off every Thursday to go to a medical appointment. Then everybody's going to want to do it. I'm just treating them the same as I'm treating everybody else, right? Well, that's where I'd be on the phone pumping the brakes and telling them, well, this person is probably entitled to take that 30 minutes off every Thursday because the Americans with Disabilities Act requires employers to provide reasonable accommodations for their employees.
They're like, what? What are you talking about?
Well,
that's outrageous, right?
Right, and usually my next comment to that is you can certainly require them to make up the time at some point, if that's the accommodation they're looking for. Another accommodation that is difficult for employers to wrap their arms around is when an employee says, hey, I have this illness, I need a bit of time off to take care of it. And in some instances, taking a period of unpaid leave, even if you're not covered by the Family and Medical Leave Act, is considered a reasonable accommodation. That's kind of the recurring accommodation request that's the most problematic for employers, because there's no bright line rule on how much time off is too much time off, such that it's not reasonable to let somebody take that time, or it's an undue burden.
Sure. So you know what I tell, I've been HR director for a number of years. Obviously, that's how we met. You're out there, you're speaking at a lot of the events I go to, and we've done business together because I'm one of those HR directors that would try and do as much as I could up to a certain point, but I just need that opinion. But I've told clients, I've told employers, I teach a lot of HR classes, employment law classes. I tell people, I say, look, because I teach these classes and people want to argue with you. They want to say, well, that's not how we do it, or that's not how we've done it. And I'll say, well, I'll tell you what. Or they'll say, my boss won't do it that way. And I tell people, look, I'll tell you, you can do whatever you want, right? But this is you, right? And I don't know if this is you. This is exposure. I am fully exposed, right? This is where you are. and you want to close that gap, right? You want to close that. It may not be completely airtight, right, or audit proof, so to speak, but if your boss wants to go out here, you do whatever you want. It's a lot of times how much exposure, I believe, right, that someone wants to take on.
Absolutely, absolutely. And that goes back to something I said earlier, which is many times I'm there to provide a risk analysis in addition to the legal analysis. The risk analysis is, well, what's the likelihood this person will bring a lawsuit in the first place? What's the likelihood they'll win? And if they win, how much will they get? You know, what types of damages are recoverable there? And many times that's the factor that tips the scales for the employer as to how they decide to go. You know, many times taking a riskier course of action just doesn't make sense from a business standpoint based on the potential exposure.
Right. So, and I tell HR folks, I say, you know what your number one job is? They're like, oh, to be, people person, all that. Well, yeah, okay, that's a lot of it. But bottom line, you're a risk manager. You're managing the risk. You are there to protect the company. Now, let me ask you, Keith. People say, "Oh, it's too expensive to get a lawyer." What do you say to that?
Well, the analogy that I've always heard is, you can pay $50 to get your oil changed every 6 months, or you can forego the oil changes and pay $5,000 every 4 years when your transmission drops. And I find that the clients that I'm in frequent contact with, and by frequent, I mean an hour per month, maybe even less, but they're the ones who pick up the phone where there's some question in their minds as to, are they doing the right thing, or is there some risk that I don't see? Those are the ones that I rarely am defending in litigation. The ones that I defend in litigation, more often than not, are referrals to me because the company has already been sued.
It's already
and now
too
we're
late.
It's too late. We're trying to unring the bell at that point.
Yeah, I use the pay me now or pay me later type of thing. I used to work at a hotel. We had an engineering director, and he'd want to order certain things, and a lot of times the general manager might, oh, it's too expensive, and he would say, look, I'll tell you what, we could spend $500 and do this, or eventually you're going to be paying me $50,000, and it usually has to do with the air handlers or the boilers, these big, asset type of things in the hotels. And he was always like, look, pay me now or pay me later. You decide, and once he laid that out, it was, okay, I'll pay you now. We'll figure out how to do that. So, one of the things that I like about you, Keith, that I've seen you said you give back, right? You give back a lot, and there's a lot of employment attorneys in town. And I would say on one hand, in my mind, if not on the tip of my tongue, their names, right? But I do know a lot of them. Only 5 of them, I would say, I see out all the time, giving back, speaking. And I know you give back a lot, and that's great. And so we appreciate that in the HR community. But you started in a large law firm, a big one, right? And you were doing well. You were their I would say their poster child, but you were the face of that law firm. And then you decided to be an entrepreneur, go out on your own. Talk to me about that decision, and then talk to me about things that companies should look for when choosing an employment law attorney. Why go with someone like you, where you have a small, I would say boutique, maybe that's an overused term, but you're a boutique law firm, right? You're a boutique kind of guy, I like that, rather than a gigantic law firm that covers all these bases. So talk about that.
Sure. And what Chuck is referring to is I was a partner with one of the largest labor and employment law firms in the country for many years. And in 2016, I decided to go out on my own and open my own law firm. And I don't know that every attorney out there will admit this, but I will accuse them of this. Everybody at one of these big law firms at some point wonders about going out on their own. And would they be able to make it? And what would life be like doing that? And, there are many that make that plunge, and I was one of them. I had recently turned 40 and kind of decided that if I don't do it now, I'm never going to do it, and it will bug me not knowing the answer to that question. And it was difficult. I loved the law firm. I loved the people that I was working with. I still do. I still have great relationships with all of them, and it's just very different now. I'm out on my own. I'm not part of a huge law firm, and there's no knock on huge law firms. They have resources that some employers need more than they would need somebody like me. You know, an individual employment attorney, regardless of my credentials, regardless of my knowledge. Sometimes you need a big firm. You need a big firm to handle a 50 state class action. I'm not going to take on that work. I'm going to send you to the big law firm there. But what I can do, and what I continue to do, is probably 95% of what I was doing with that large law firm, which is the day-to-day advice for clients, defending them in litigation. And I'm still out there, as you know, Chuck, speaking to the HR community frequently at seminars and doing podcasts and webinars and the like. You know, what should you look for in an employment attorney? I would say this: the very first thing that you should have is a comfort zone with your employment attorney. I have clients that I've known for a week, and I have clients I've known for 20 years. And you will get the same white glove treatment from me regardless of which category you fall into. If you need to call me on a Sunday, I'm available on a Sunday. You need to call me at night, give me a call at night. But the biggest thing is having that kind of personal rapport where it's not a drag to get on the phone and call Keith to hear his answer. I don't want to listen to an attorney who bores me with 90 minutes of legal analysis before telling me the answers I don't know. And Chuck, that's not my style. If the answer is I don't know, I'll tell you I don't know, and here's the reason why in 90 seconds or less rather than 90 minutes. So that's the big thing. Obviously, expertise plays a role there too. You probably would not want to go out and retain a first-year law associate as your primary provider of legal advice. No knock on first-year attorneys, but they just don't have the experience to provide meaningful advice that you can rely on and have to go to the boss and defend your decision with. Now, that's not to say you need to find yourself a 20-year lawyer or a 25-year lawyer, but you do want somebody who knows what they're doing, who knows all aspects of workplace law. I think I listed them in the beginning, but you've got laws like Title VII, the Americans with Disabilities Act, the Age Discrimination in Employment Act, OSHA, to some extent ERISA, which covers many benefit plans, workers' comp retaliation. There's just a number of different expertise fields that you probably want your employment lawyer to have. And so in that regard, the other thing, Chuck, that I think that I do is I work very closely with the hospitality community here in Orlando because that's a major segment of our economy. I have many people that I will dole out off the cuff kind of advice or give them my thoughts on something after one of these seminars where they catch me, and want to chat for 5 minutes or so. And I never open a file. I never send them a bill for that. I have, some that call me to this day, just, 5 minutes every couple of months, every 6 months or so. And it's good to know that I'm the person that they think of when they've got a sticky situation that they need some quick assistance with. And sometimes those people end up becoming clients. Those employers end up becoming clients, and sometimes they don't. And if they don't, that's fine with me too. The way I see it is those individualized calls are kind of like me going out and speaking at a seminar, just with a much smaller audience.
Right. And I would say one of the best aspects, and I would tell this to anyone that wants to be an entrepreneur, is you're really good at connections, right? Making connections, keeping connections, being out there. So when you made that jump, I remember when that happened, but it wasn't as if you were starting from the beginning. You were already plugged in. And I would say any entrepreneur that wants to make that jump needs to be really good at having connections, making connections, and keeping connections. Correct?
I think you've hit the nail on the head. Many clients are still clients of mine after many years. I represent mom and pop restaurants, and I represent very large companies. So it really runs the gamut. And like you said, Chuck, I think the most important thing is the relationship. Being comfortable with your employment attorney, having an excellent relationship, having an open and honest relationship. You know, one of the hats that I wear isn't only to be an advocate for you, but also to be your advisor. And sometimes that means I'm the bearer of bad news. And you know, there are employers out there that like to shoot the messenger, but in my experience, that really doesn't happen with me too much. And I'd like to think that it's because of the relationship that I build with clients, where they're comfortable knowing that, hey, if this wasn't actually, you know, a risk, Keith wouldn't be trying to scare us with it.
Right. And, you know, it's funny. We were talking a little earlier. So I do, as after many years as an HR director, corporate HR director in the industry, right, I decided to go out on my own, but you have to stay up to date on things. And so some of my resources, Keith, I was just sharing this with you. Oh, yeah, this thing here. Oh my gosh. The complete guide to HR, Keith. This thing is, oh, I don't know. You can't even tell how many pages, because in each section 30-15, 40 there's 42 sections in here. I have this, and then I have this, the complete payroll answer book, in addition to researching everything. It's a lot to keep up on. So I know that folks can call me. I can help them out on a lot of things, but at times I know I'm always amazed when I call an employment attorney, even as how much knowledge you folks have. But this is, don't try this at home, folks. You know? Keith, can I ask you, and we've alluded to this, but just talk to me about how could folks get in touch with you, and what would be their experience once they do? I know your website, you can share that, a lot of great resources on your website, but let's talk about how people could get in touch with you.
Sure. Certainly you can visit the website, which is www.hammondlawcenter.com, all one word, or just pick up the phone and give us a call. Our number is 407-730-9909, or you can send an email to the address admin, ADMIN, at hammondlawcenter.com. You know, right. You know, just a very brief statement of what the issue is and how we can get a hold of you, and we'll call you back that day. You know, it will not be more than 24 hours before you hear back from us.
Awesome. So in the show notes, I will go ahead and put that information. I'll put that information.
Great.
Keith, is there anything I didn't cover today? Anything that you'd like to get out? And I tell you what, you're bringing up some great topical stuff today. I'd love to have you back on the show at some point in the future. But tell me, is there anything else I missed today that you want to just share?
No, I think we've covered quite a few bases today, and I want to thank you again for having me on the show. I'd be delighted to come back anytime. And, you know, we live in a society right now where things are going day by day. And now more than ever, it's important to stay on top of the changes to the law so that you as an employer remain in compliance with a number of laws that are changing out there. So on that note, Chuck, both you and I are in the same boat. We're both trying to help our clients as best we can and make sure that they stay clear of the rocks sailing this close to shore.
Awesome. Well, folks, thanks for joining us on this segment with Keith Hammond, Esquire, right? Keith Hammond, Esquire. I'm Chuck with Alliance HR Partners. This is the HR and Spotlight Leadership Show. Folks, I love HR, and I hope you do too. Until next time, be safe out there.